Madam Clerk. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Welcome, everyone. The court calls case number 255A19-1 N. Ray K.H. Ms. Wright.
Thank you, Madam Chief Justice. May it please the court, my name is Annie Wright. I am counsel for the appellant respondent mother in this matter. I'd like to reserve 5 minutes for review.
You may.
Thank you. This is an appeal of a termination of parental rights order. So to protect the identity of the juvenile, I will be referring to the juvenile by the pseudonym which was used in the briefs, and that pseudonym is Caitlin. And I will be referring to the respondent mother by her first name only, and her first name is Giselle. And the state, through the Department of Social Services, has had generational involvement in this young woman's families. Giselle was removed from her biological parents' care by the Department of Social Services when she was at a young age. And when she was 8 or 9 years old, she was adopted by a new family. Things remained troubled with that new family. The Department of Social Services continued to have involvement. They did some in-home services in 2015 and 2016. Giselle gave birth to a daughter of her own in June of 2016. And in May of 2017, Giselle reported that her adopted father had punched her in the face for having boys in the house when her parents weren't home. The department took a more drastic intervention at that point, and they obtained non-secure custody of Giselle and of Caitlin. They were in separate placements for a couple of months, and then they were able to live together in the same foster home beginning in June of 2017. They stayed there until October, when they were moved together to the Church of God Children's Home. So from April of 2017, when non-secure custody was obtained, until April of 2018, Giselle had some problems, but things were going fairly well. The permanency planning order that was entered in this case in April of 2018 said that the department expected that they would be reunified with custody back to Giselle within 6 months once she completed her parenting classes that she was taking with an educator named Marley Cook. In December of 17, there was an issue where Giselle was caught smoking cigarettes, and the Church of God staff searched her room and they found a shoebox with marijuana stems in it. So they separated them as far as living together. And that was intended at the time to only be temporary, because like I said, the PPH order was entered in April, which said we expect issues to be resolved enough for reunification within the next 6 months. And during this time, between April of 17 and April 18, Giselle she completed some substance abuse treatment. She did parenting classes. She was basically compliant with her case plan that she developed with the department and with the department's requests. In late April of 18, she tested positive for marijuana. And then in early May, just about a week later, the Church of God Children's Home told the department that she needed a higher level of care and that they could not keep her there anymore. So she was moved to another group home. Things did not go well there. She was again discharged. Then she was moved to another group home where she stayed for a few months. They also told DSS she needed a higher level of care. So then she was moved to a group home in Greensboro. That only lasted about a week. They also told DSS she needed a higher level of care. She was put in another group home where things went okay for a few months. But at the end of November 2018, the owner of the facility where she was staying picked Giselle up from school, and they took off together. And she was, missing from the facility. There was an assault that occurred. And as a result of that, she was put into a therapeutic foster home at the beginning of December 2018. Now, her therapist had been recommending a therapeutic foster home since at least the beginning of September, but for whatever reason, even though these higher levels of care had been recommended for quite some time, the department had not been able to get her into one. Once she did get into that therapeutic foster home, things went really well. Now, she got into that therapeutic foster home at the beginning of December, and the termination hearings were held at the end of February. So we're talking about, December, January, February. But during that time, she was attending school regularly. She was doing well in school. She was on track to graduate. She was taking extra classes so she could graduate on time. She wasn't having any behavioral problems in the therapeutic foster home. She was following all their rules, curfew. She's not using drugs or alcohol, and things were going well. During the period of time where she was decompensating and going through all of these placements, she was also not able to engage consistently in therapy, to do parenting classes, to do the services that were recommended. And in August, kind of in the middle of that time, the department filed the petition to terminate her parental rights. So when the hearing was held at the end of February, the trial court found that there were 3 grounds that had been sufficiently proven to terminate her parental rights. Those are 7B-1111, A2, A3, and A4. A3 is the ground that allows for termination of parental rights if a parent willfully fails to contribute a reasonable amount to the financial cost of care of the child. Under those grounds, the trial court looks at the 6 months before the petition or motion in this case was filed. And the trial court made findings of fact about 3 sources of income that Giselle had. One was an allowance that she got for chores in the foster home that she was living in at the time of the termination hearing. Because she was placed in that foster home after the petition was filed, that allowance does not fall within the statutory 6-month framework. There was also a fast food job that she had, which also fell outside of that 6-month window. So there was a finding that she worked for some period of time at Shoe Show. We don't know how long. We know it wasn't very long, and we know it was sometime in 2008, but the findings of fact and the evidence don't show when in 2008. And so for that reason, this ground fails because there's just not the findings of fact within the relevant time period to sufficiently support it.
Would there also be error in the fact that the trial court only said that there was some amount that was earned by her that was greater than 0 without quantifying what that amount was?
I think that there's case law out there that says that if the trial court says that a reasonable amount would have been some amount greater than 0, and that the parent didn't pay any amount greater than 0, and the parent had some earnings, then that is sufficient. But I think in this case, there would additionally be error in the fact that this is a teenager who had a couple of, after school part-time jobs and an allowance. And it does not appear from the findings of fact that the trial court took into account that this is an unemancipated minor. There is a case that I filed with a memo of additional authority earlier this week. It's Whitman v. I think Klinger, in which this is addressed. And the North Carolina child support statutes say that when you have an unemancipated minor parent, that unemancipated minor's parent, the grandparents of the child are also primarily liable for child support because unemancipated minors have a limited ability to earn and manage income. And that Whitman case specifically says that that minors are legally incompetent to give consent for most purposes and need responsible, accountable adults to handle the property and their property and benefits. In this case, DSS had custody of Giselle, and they were that responsible adult.
Just to make sure I'm understanding you, Ms. Wright, are you arguing at this point that unemancipated minors are not subject to termination under A3, or are you arguing there's some deficiency in the way that the trial court actually considered this issue other than the failure to make findings that are focused on the specific period set forth in the statute?
Yes, sure. My primary argument is that the trial court failed to make findings in the relevant 6-month period. But I just wanted to add that this is not just a form over function issue, because there is an issue about her ability to earn money or willfully fail to pay during that 6-month time period. Another ground was the A6 ground. This is the dependency ground. The ground that says that.
I'm sorry, Ms. Bright. Let me back up a second just to make sure that I understand your argument about here to make findings with respect to the statutory periods out in A3. What specifically is in error in the trial court's ruling based upon the second of your 2 points?
Well, I think that would depend on, so during this period of time,
I mean, the trial may be a little bit more specific. The trial, it's clear from the order that the trial court understood for a portion of the time prior to the hearing, the mother was not emancipated. Subsequent portions, child had become emancipated. So is it your contention that the trial court is required to make some addition dealing with the emancipation issue? Is your argument that until the trial court until the juvenile becomes emancipated, that their parental rights can't be terminated? What's the effect of this argument that you're making for purposes of this case?
For the purposes of this case, Your Honor, my argument is that the trial court failed to make the findings in the regarding the relevant time period. I'm not asking the court to make a holding that an unemancipated minor's parental rights can never be terminated under A3. I would note that I don't think there are any appellate cases that have affirmed that ground for an unemancipated minor, but I'm not asking the court to make that holding here.
Okay, thank you.
Thank you. So 6th ground, that's the dependency ground. This is the ground that says that a parent's rights can be terminated if they are incapable of providing for the proper care and supervision of the juvenile. And this incapability, is likely to continue for the foreseeable future. And it's a 2-prong test. So if that first prong is met, then the second prong is that the parent who suffers from the incapability must not have an appropriate alternative child care arrangement. In this case, the home where Giselle was living at the time of the termination hearing was with the therapeutic foster parent, where things had been going well. And that therapeutic foster parent testified that there was room in Giselle's bedroom for, Caitlin's bed and things like that, and that she was more than happy to have Caitlin come and live in the home with them. This is an approved therapeutic foster home placement. It is appropriate. And so Giselle did have an alternative appropriate child care arrangement. And the trial court also did make findings regarding.
So is your argument that the trial court's findings are deficient, or is your argument that the evidence didn't support the finding that the grounds for termination exist under A6, or both?
So if the finding of fact regarding the lack of alternative child care arrangement is lacking, then the usual appellate remedy is to remand for findings of fact on that. So I'm arguing. Is
that what you're asking us to do with respect to this issue?
Primarily, my request would be that this court reverse, because based on the evidence, she did have an appropriate alternative child care arrangement. But alternatively, this court could remand for additional findings of fact on that issue. But given the evidence, my request would be that that ground be reversed. Which brings us to A2, which is the ground which allows for the termination of parental rights when a parent willfully leaves a child in foster care or other placement outside of the home for more than 12 months without showing reasonable progress under the circumstances to correct the conditions which led to the child's removal.
That's right. Let me ask you a threshold question on A2. Which of these two arguments are you making? First, are you making a bright line argument that when a parent and child are placed in the same foster home, A2 can never be triggered? Or are you saying that in theory it could happen, but it didn't happen on the particular facts of this case?
I am making an argument and then an argument in the alternative. So I would argue that under the facts of this case, where you have an unemancipated minor who is the parent, who is in DSS's foster care, and another juvenile child of that parent who is also in DSS's care, and they are together in the same home or facility, that 12-month time period, the time when they are together does not count towards that 12-month threshold. I am making that argument because the statute says willfully left in foster care or placement outside the home. And the congenital statutes define foster care as a situation where a child is living apart from a parent. And so if you look at the definition for foster care, if you look at the modifier outside of the home as it applies to placement and to foster care, and also the use of the word removal in that same sentence, then I think that shows that the legislature intended for there to be 12 months of actual separation. And that intention is there to preserve the state's interest in family preservation. And I think that the legislature actually intended it. But if this court is not persuaded, I am also making the argument that her progress is reasonable under the circumstances.
Well, let me ask you a question about the first of your two alternative arguments here. Are you contending that simply that the period of time in which both of them lived in the same care arrangement, which would be excluded from calculating the 12-month statutory period, or are you arguing that the 12 months has to be calculated based upon a consecutive period of time prior to filing the petition?
I'm not making the consecutive argument. I think there's case law out there that says that the 12 months does not have to be consecutive. I am making the
all you're saying is that you can, from whenever that there, as long as there is a cumulative rule of a 12-month period in which a child does not live with the parent, regardless of the reason, that period, that's a sufficient 12-month period. But if there's not 12 months because the two are living in the same arrangement, even though both of them are technically in foster care, that time would be excluded.
Yes, Your Honor. And in this case, even if looking at the time that they were not together non-cumulatively, we only have 9 months before the motion to terminate is filed, and the 12 months is measured in the time before the petition is filed. So, the trial court is not to count the time between when the petition or motion is filed up to the termination hearing for that first prong of A2, the 12 months.
Okay, thank you.
So as to the second prong of A2, and I would add that this first prong is jurisdictional. I believe it's the ACF case that's cited in my brief that says that if this 12 months does not exist, then the trial court does not have the jurisdiction to go on to the second part of the A2 test. And so the second part of the A2 test is whether or not the parent made reasonable progress under the circumstances.
Before you go into that, I have one quick question. I just want to make sure I understand your argument about the A2 issue and the time period when the mother and the child were both in the same therapeutic foster care together. That's excluded, but am I reading the record incorrectly? Didn't that happen after the petition was filed anyway?
Giselle, the respondent mother, was placed in therapeutic foster care in December of 2018, which is after the petition was filed. But when non-secure custody of Giselle and Caitlin started in April of 2017, from April of 2017 to the beginning of June 2017, Giselle was living with her godparents and Caitlin was living and in a foster home placement. So we've got 2 months where they are living apart at the beginning. And then we have that period from June to October when they're living together. And then, or not from June until December, sorry, where they're living together. And then we have the issue with the cigarettes and the marijuana stems that occurs at the end of December 17 when they're separated again. So
And the petition was filed in August.
August 8th, yes. So
So the 12-month period has to be before that, correct?
correct.
Okay, I just want to make sure I'm getting the sequence. I'm following that. Thank you. Sorry to interrupt you. Go ahead.
Not at all. So when we get to the second part of the test, built into the language of the statute is that this is a case-by-case determination, reasonable progress under the circumstances. If you look at this case, Giselle was making reasonable progress as recognized by the PPH orders for a year, from April 17 to April 18. She begins to have issues at the end of April 18 and the beginning of May. And she gets moved around to all of these different placements. And all but one of those placements says to DSS, she needs a higher level of care. And the therapist is saying to DSS, she needs a higher level of care. And for whatever reason, she doesn't get into that higher level of care until December. So we have this period between April and December where she's being moved around. She is not able to do parenting classes for various reasons. Marley Cook, the woman that she'd been working with, they tried to get her in place in some of these other placements, and it just didn't work out. She was in Mecklenburg County in a placement for a while, and the department didn't make any referrals for her to get parenting classes there. Her therapy was inconsistent. This is a young woman who had been removed from a bad home by DSS as a young child and then put in another home that had problems. Her therapist testified at the termination hearing that she had suffered trauma, that she had oppositional defiant disorder, she had ADHD. And so, looking at these circumstances, the trial court erred in finding that her progress wasn't reasonable. When she was getting the support for the whole first year of the case, she was making progress. And even when things were decompensating, so to speak, she was still having good visitations. She was still maintaining contact with the department. She didn't miss a single CFT meeting. I think there were 72 visitations and she missed 7.
So your contention that she was not making reasonable progress because the county's decisions concerning her placements were thwarting any efforts that she may have made herself if she'd had more control over her own placements and decision-making opportunities?
Yes, in the sense that she was in their custody, and even in a case with an adult parent, the Department of Social Services role is to make reasonable efforts to give referrals and help with transportation and all the things to help preserve the family and help solve whatever issues led to the DSS involvement in the first case. In this case, she's a teenager in DSS's custody. I'm not going to say that, she's not a perfect teenager. I'm not saying it's all DSS's fault for not getting her in a better placement, but I'm saying the circumstances where DSS was not able to get her into that higher level of care and able to, secure a continuity of services are part of the circumstances that the trial court needed to look at more appropriately in terms of whether or not her progress was reasonable.
So are we to evaluate that her progress is to be measured in terms of it being reasonable progress based upon the circumstances in which she found herself, or are we to apply her reasonable progress against the more standard parent who is in a position where that parent controls his or her own destiny to make certain decisions?
I would say the first, Your Honor, and I would say that's what the statute dictates, that under the circumstances, meaning that particular parent's circumstances.
So perhaps to adopt a colloquialism, we ought to take her where she is in her life in terms of what is reasonable considering where she was in life at that point.
Yes, Your Honor. At the termination hearing, there was a lot of emphasis on Giselle not being able to, actually, I see that I'm at my time, so I'm going to end there unless someone else has another question.
Thank you, Ms. Wright.
Thank you.
I understand that Mr. Entwistle will argue for 20 minutes and Mr. Peterson will argue for 10.
Yes, Your Honor.
All right. You may proceed. Thank you.
Please, the court and Madam Chief Justice and the justices of the North Carolina Supreme Court, good morning. My name is Dutch Entwistle, and I work at the law firm Hartzell Williams here in Concord, North Carolina, and we represent the FLE, Tavares County Department of Social Services in this case. And Your Honors, at the heart of this case is a mother whose parental rights were properly terminated on the basis of her own willful failure to make reasonable progress under the circumstances to alleviate or address the concerns that led to the removal of the juvenile in the first place, and her similar failure to pay any portion, even a reasonable portion, of the cost of care for that juvenile. And even though the appellant would articulate to this court that there are certain procedural defects, a full reading of the cases that are cited in her brief, as well as consideration for the unchallenged findings of fact. Yes, Justice Ervin.
Do you concede that there is no finding in the trial court's order concerning the availability of an alternative care arrangement for purposes of A6?
Your Honor, in my brief, I did concede that point. What you will be hearing from Mr. Peterson is his take on that, and I'll submit to the court that I believe he saw that issue more clearly than I did at the time of writing the briefs. However, I cannot delineate from what I submitted to this court in my brief. So yes.
You didn't act in concert in drafting your briefs.
Well, not on that issue, Your Honor.
Okay, thank you.
And in turning to the issues that I did address in the brief, starting with, I think a timeline is helpful. I think Ms. Wright did do a good job of kind of breaking down when events happened. But what happens in this case is on April 5th, 2017, the trial court issues a non-secure custody order granting my client, the Department of Social Services, non-secure custody of the minor child, and ultimately the motion to terminate was filed on August 8th. So on its face, the time period between the non-secure custody order and the filing of the motion, that's 1 year, 4 months, and 3 days. And so the issue then turns on whether the appellant, as she suggests, gets to deduct any time from that relevant time period. And
I'm sorry,
Your Honor.
If she gets to deduct it, is her position correct?
If she deducts the entirety of the time that they were placed together, yes, Your Honor.
So this issue rises or falls on the basis of what we do with her deduction?
As to A2, yes, Your Honor, I believe that's correct.
Okay, thank you.
And to break down a little bit further the subparts, the mother and child were placed in a foster care for a period of about 4 months and I believe 18 days. And then they were placed in a place called Church of God, which for all intents and purposes is another foster care facility for a month and 22 days. So, and I'll get to maybe the appropriate delineation of what a foster care is here in a moment, but turning to the JGB case upon which the appellant relies, that is not a case that stands for the proposition that where a minor parent is placed with a minor child, you cannot count the time that they were together. Instead, that case was decided purely on the issue of whether or not, just as in the Henry Matherly case before it, but whether or not the trial court properly considered or paid heed to the age of the minor parent and that effect on willfulness. And it was on that ground alone that that case was remanded for additional findings. It was not reversed. And importantly, I think for today to address, and Justice Morgan, I'm sorry, I didn't mean to cut you off.
Oh, thanks for surmising that I had something that I was about to ask. Very astute on your part. What would be your response to opposing counsel's position that the legislative intent would be discerned to be that there must be separation between parent and child, and that this would not be the way in which the statute should be considered?
Your Honor, I think that's an excellent question. And actually, part of the holding in JGB is instructive towards that. But then there's another case that appellant relies on that I think even more directly speaks to that issue. So starting with the jurisdictional analysis that the JGB court did, you would find in that case that they refer the reader's attention to 7B-1101, which specifically gives trial courts jurisdiction in this state to terminate a parent's rights despite their age. I think it even uses the phrase regardless of their age. So what you will glean from the jurisdictional statutes, which the JGB court did, is that there's not a special protection placed upon these minor parents. And to some extent that makes sense, because if these minors are engaging in acts that lead to children being born and they're taking on that adult aspect in their life, for practical argument, it makes sense that we're holding them accountable because these cases are about the children. It's not necessarily directed at the parent or their behavior. It's about how do we get the kids right. But turning to the other case that is cited by the appellant in her brief and mentioned here in oral argument today, that is the case of In Re ACF. And Your Honor, what I think ultimately the issue may turn on today is how do we classify the phrases left and removal in section 1111A2. And you have in ACF a direct analysis that is taken in part from a prior Supreme Court case from this court in Pierce, where the facts of Pierce that is discussed in ACF are this. In June 1997, you have an intervention by Department of Social Services pre-litigation. And in that month, there's either a voluntary plan put together where the child is taken from the home to address these concerns. And ultimately, those concerns are not addressed. So 2 months later, in August 1997, you have a petition that's filed, non-secure custody is granted. And then the following year, in June of 1998, you suddenly have a petition to terminate or a motion to terminate being filed. And if you're keeping track in that timeline, you have the June 97 which was pre-litigation removal. And that's the department was trying to have that corroborate with their June 1998 filing. But what the court ultimately determined in Pierce, the Supreme Court said that, well, we start the clock at the time the non-secure custody order is entered. And the reason why, as discussed in the ACF case, that makes sense is because when you look at the phrases of left and removal, because they're not defined, the Court of Appeals and ACF engages in this discourse of, okay, well, there's a range of definitions we can give these words, and at either end, the results are nonsensical. If it's too loose, then you have a situation where we are saying that parents who drop their kids off at daycare, if DSS comes in the meantime, that suddenly we're tracing back to that date, and that doesn't make sense. But alternatively, if you're too narrow with your interpretation, you might exclude involuntary removals under other circumstances. So the ACF court says, I'm sorry.
Does the mother, in this case, does the mother leave her child in foster care, or is the child deemed to be removed to foster care if there is placement with the mother because the mother herself is in foster care?
Excellent question. And that gets to ultimately the idea of the intent that was asked about a moment ago. And it's the intent of these statutes. And I agree that you need to read intent here, that there is some type of non-consensual removal. And what the ACF court says at the end of its case and its holding is that so long as a parent it maintains consent as to where their child is placed, the child is not removed. So what we need then is a line in the sand, which in these cases, it just so happens in ACF, Pierce, and here, there is a non-secure custody order that starts the clock as to when somebody is left anywhere. And Your Honors, if you read the non-secure custody order in the record in this case, you will see that it's an AOC standard form. I believe it's J105. But in that order, it is the department who's vested with custody, and then it says they can place in foster care or other licensed places. So at that point, it is the department's consent. It is not mother's consent, father's consent. The department has taken, or the child has been removed and placed into the department's upkeep, caregiving, whatever phrase you would like to place on it. And I'd submit to the court that the very case cited by the appellant in her brief speaks to how we address this issue of where do we start the clock. Even if you look at the face of the statute, I think it's relevant here because the appellant was placed with her child in foster care. So there's no dispute as to whether or not the statute as written addresses the situation because the child is in foster care. So that much of the phrase is not disputed. Yes, Your Honor.
The decision to place the mother and child in the same foster home is not coincidental. It's deliberate on the part of DSS, right?
Yes, Your Honor. And that's an excellent point in terms of putting this all into context because
let me just move on from that. When that happens, the parent and the child are still spending time together and living under the same roof. So doesn't it seem a little doesn't that scenario seem a little inconsistent with the notion of them being separated through foster care?
In a vacuum, Your Honor, but what the record actually shows in the permanency planning hearing orders is that even whenever they were placed together, it is still supervised visitation. So this is not a situation where mom and daughter are given a house and they're able to do whatever mom and daughter want. This is a situation where DSS or a foster parent or an entity in control of the situation dictates the engagement of supervision.
So your argument is in essence that because the mother was in foster care herself, as was the child, that effectively results in a separation and therefore precludes tolling of the period during which they live together. That's in essence what you're arguing.
Yeah, I want to answer your question directly, Your Honor. I'm going to say no, but I might talk myself out of it to say that this is a situation where there were independent grounds for non-secure custody of the minor child to be taken from the appellant. This is not a situation where the appellant was in our care and then the child placed after the fact.
So let me restate it and see if I can get it right this time.
Okay.
If I understand your argument, I've got a better chance of deciding whether I agree with it.
Yes, Your Honor.
You're saying in effect that because both the mother and the child were independently taken into foster care, even though they lived together during the period from during the period of time that Ms. Wright seeks to have excluded, that the fact that they were both independently in foster care precludes the determination that the child had not been removed from the mother's care.
Yes, Your Honor.
Okay, thank you.
Can I follow up on that to just understand then from your view, what could the mother have done to not be leaving her child in foster care? I mean, how could...
Your Honor, she could have been making reasonable progress.
Well,
and
except
she
that
could have,
you're saying that the fact that they were placed together doesn't count as them living together, that because she's in foster care and the child's in foster care, that counts as part of the 12 months. But it sounds like the only way that she could not, that would not be true is if she herself weren't in foster care. And how would she make that happen?
And Your Honor, I'll certainly concede that this is a peculiar issue to cases where there are minor parents. And the case could have gone really two different ways. It could have been that they were placed together during a time where reunification was the primary goal. And that's what happened. The department saw fit to say, we want to encourage reasonable progress. We'll place you together, prove that you can follow your case plan, that you can stop taking drugs, that you can stop running away, and do that together. And ultimately, the result here almost kind of proves the point where that's not what the appellant did. She gets kicked out of the foster home because she's stealing money and prescription drugs from the foster parents and running away. And then at the next placement, yes, Your Honor.
But on your theory, the time that she is living with her child, they're both together, that doesn't count. That's still the child being in foster care.
They are both in the custody of the department, yes, Your Honor, due to non-secure custody orders. And as the custodian, they've been placed together. However, that is not in the home of the appellant for the purposes of calculating that time period. And that comes from the ACF and Pierce analysis that says you leave your child when you create grounds for non-secure custody to be vested in another entity.
Well, she is, the mother is in non-secure custody, at least in theory, because of the activity of her new parents, right?
I'm sorry, I didn't hear you, Your Honor.
The mother is in non-secure custody or the custody of DSS because of activity of her parents, not her own activity, right?
Correct. Yes, and to the point to maybe before I move on to talking about the grounds under A3, had the appellant been able to conform to the case plan, then there are options to do practice placements with a parent. And had we been able to find a place for her to be set up that doesn't qualify as a foster care, but could have otherwise qualified as placement outside of the home, we could have been in a situation where I think the appellant could have been working towards or not working against the clock set against her. But at the time they were placed together, there were still concerns, and she was supposed to be working on those concerns, and in the custody of DSS did not do so, and the clock continues to run because she left them at the time of the entry of the non-secure custody order.
So let me ask you before you move on to the next issue.
Yes, Your Honor.
What exactly where in the timeline are you talking about when you're referring to?
This is in from June 2017 until December 2017, Your Honor. Then when they were together, if that's your question.
June 2017 to December 2017, they were together. Was
June
this
to
during?
December, yes, ma'am.
Was this during the time period that DSS was recommending that she needed a higher level of care?
I do not believe that was the testimony. She started, so first of all, when that therapist came in and when she started making recommendations is not really clear from the testimony. I do believe that she became involved to suggest that in a later stage, but to rebut a little bit of what the appellant suggesting that the department didn't do what they needed to do, what you have is an appellant who's running away from placements, continues to get caught with drugs. The department cannot snap its fingers and find fitting placements when the first questions that are asked are, okay, what are your concerns? Because we've got to match them up with what they need and also what can be provided to them. So that's what we run up against in cases like these.
Well, as I understood the argument by counsel for the mother was that at least during some of the time period from April of 2018 and May of 2018, that DSS was right, that the homes were saying that she needed a higher level of care and that was not able to be found. And I guess my question is, what's your position about how that bears on her ability to make progress under those circumstances?
And Your Honor, the recommendation for higher level of care is somewhat nonspecific. Higher level of care can be not in foster care. It can be placed with an institution like Church of God. It can be placed with Jireh's Angels. And as she was put from placement to placement, the problem was she continued to do all the negative behaviors that appear in the record, negative drug screens, stealing from the people who were taking care of her. And when she continues to do that, that is what's creating the problem. And it's that willfulness, that knowing what she needs to do, but not doing so, that led to these issues of placing her. And so, yes, and as of December 2018, she was placed in a therapeutic foster home. But that is, there's a natural progression of what higher care could look like. And yes,
well,
she got there.
If the recommendation was that she needed a higher level of care in order to make more progress, and she wasn't getting that, and you're saying that, well, she wasn't making progress, so therefore that counts against her. That sounds a little bit of a chicken and egg problem.
Well, I think my point is more that the issue with placement came from the difficulties she created. So she can require higher levels of care, but getting her matched up with places that can provide that to her, it's not as simple as it might be if her issues weren't present. I would leave it at that. I don't know if I'd go a step further.
Okay.
And before I run out of time, I'd like to address the grounds for A3, and I'll do my best to be brief here. I want to be respectful of Mr. Peterson.
I just want to follow up. I want to follow up on Justice Earle's question. Your argument's a little bit of a square peg in a round hole, isn't it? Because normally with A2, we're dealing with the idea is we want the parent to follow the case plan and do a better job. And on their part, the goal is to be reunited with the child. But if the mother and the child are already living together, how is that normal premise operative here?
I agree that for minor parents, it is an issue peculiar to these cases, Your Honor. And I would say that had the statute intended to give special protections or special discounts of time, they could have written that in there. But instead, what the statute says is that these apply equally across the board. And while Matherly and JGB require extra consideration to their age as to willfulness, none of those cases, nor any cases I'm familiar with, actually create an exception where minor parent and minor child are placed together. Turning briefly to grounds A3, the argument that I hear from appellant comes from her brief and oral arguments is that somehow the burden has been misconstrued, that we have to prove that the appellant was employed during the relevant time period. That is not the standard. We have to prove that she was physically, financially able to contribute to the reasonable cost of care. Case law cited in my brief suggests that we don't have to figure out what a reasonable cost of care is, so long as she is gainfully employed from time to time. Case law says that she cannot pay zero. Zero is never reasonable under those circumstances. And Your Honor, for those reasons and the ones mentioned by Mr. Peterson here in a moment, we ask that you affirm the trial court's termination of parental rights.
Well, wait a second. Isn't the standard that the trial court has to make findings that she was employed during the relevant 6-month period?
Not that she was employed, Your Honor, just that she's physically and financially able to contribute. And if she forfeits the ability to financially contribute due to her own misconduct, which is the case here, she was fired for not showing up, then she does not get to argue. And in fact, she's precluded from arguing that she is unable to provide any amount towards the cost of care.
Is there a finding that is specifically directed to the statutory 6-month period? It looks to me, I read the order to talk about essentially over a broader period of time. Is that wrong?
And Your Honor, well, Your Honor, I think sometimes whenever courts do cite the exact language of the statute, they're accused of not applying the facts. And if they only apply the facts and don't use the language, then they're accused of not using the proper language. The trial court's order does say
that may be, but it seems to say that both there was substantial testimony throughout the course of this case at various points in time. The respondent was employed, etc.
Mm-hmm. And Your Honor, what that speaks to is that she was able to work. It speaks to her ability. And the fact that they mentioned the grounds, you know, and I don't want to take up more of Mr. Peterson's time, but if it's true that the court order could have been more specific as to that time period, that would indicate a remand is appropriate for findings addressing the evidence that we know is in the record where she could work, but she didn't because she was fired for not showing up.
Okay, thank you.
Thank you, Your Honors. And thank
May it please the court, Daniel Peterson from litem, and thank the Honorable Supreme Court for hearing our arguments today. My focus will be primarily on addressing the correct finding with regard to dependency by the trial court. I mean, as the court knows, dependency has two basic prongs: whether the parent has the ability to provide care or supervision, and two, whether the parent has appropriate alternative child care arrangements. And as we say, the appellant has only challenged the trial court on the second of these prongs in this appeal. Moreover, given the facts as my colleague ably discussed for the department, there would be no good faith basis to appeal the notion that the appellant has the ability to provide care or supervision to her toddler daughter. Thus, appellant's argument focuses solely on the purported failure of the trial court to make a finding specific to the second prong, again, whether she had appropriate alternative child care arrangements. Appellant contends that the trial court was somehow required to accept testimony that her final placement before reaching the age of majority was an alternative child care arrangement for her child. Importantly, and again, appellant does not contend that she is appropriate, just that her place was. While the trial court did not use the rote phrase, quote, appropriate alternative child care arrangements in its order, somewhat speaking to my colleague from the department's last comments on how the trial court can sometimes get in trouble without using the magic words, to coin a phrase from this court's recent opinion in the matter of KRC 845 SE 2nd 56 at 64, the trial court squarely and methodically addresses this issue in its order at record page 212, paragraph 48. Indeed, this issue in many ways is the reverse situation of KRC, where the trial court used the magic words in that case, but this court found a lack of substance to support those words. The substantive analysis by the trial court here discloses that the trial court considered alternative child care arrangements. For example,
Mr. Peterson, where on page 212? Where on page 212 of the record does the trial court make a finding about alternative care arrangements?
Yes, Your Honor. It's within paragraph 48, and I'll walk through what I feel is the substantive findings on how we reach the alternative child care arrangements.
Because I see a whole bunch of findings why the status of dependent may exist. I'm having some trouble finding the alternative care arrangement.
Well, the alternative care arrangements, as the appellant notes, is with regard to her last placement here. And as the trial court notes in subparagraph A, the respondent turned 18 years old, or the age majority, on February 10th, 2019. In that same subparagraph in A, the trial court overviews the appellant's catalog of behaviors, which importantly include running away and illicit drug use. So the trial court is noting that there's been some improvement by the appellant once she was placed in custody in her last placement, but that the 12 weeks of modest improvement were insufficient to overcome her history of previous issues. And so the court, by discussing these notations, reaches this alternative child care arrangement that noting the age majority, and the appellant has no legal requirement to have anything to do with this former placement, Your Honor, and can leave at any time. So we know that the trial court considered this by...
I'm sorry, Mr. Peterson. What's that got to do with an alternative child care?
Well, Your Honor, it's simply, the appellant simply suggesting an alternative and permanent foster care situation for her child, whereas where she is right now, this toddler is in a stable home and currently finds herself with parents that are willing to adopt her. That's what that has to do with it. Those two concepts wedded together make it clear that the trial court is considering whether the appellant's last placement would be appropriate for this, for her minor child.
Ms. Peterson, there's a long line of cases, there's a long line of cases, as you know, that says there must be an express finding on this issue, and it's just not here. If we accept your argument, that eviscerates the requirement that trial courts make that finding that we've said over and over again, and the Court of Appeals has said over and over again is required. And again, in one of the briefs from the appellees, there's a concession on this point.
I understand I would just say that the express notion of it, I mean, we want to prefer the function over the form here, and another notation here in paragraph 49 is that the juvenile is doing well in the current foster care placement. I mean, so there are notations here, there are findings rather, not mere notations, findings that show the trial court is thinking about this issue, is making findings related to this issue. And my focus as, appellee for the guardian ad litem is on this toddler who would be thrust into a chaotic position when, frankly, the record appears clear that the
Are you able to cite a single case from this court where we've said this type of finding is enough on that issue?
I'm not, Your Honor.
Thank you.
I'm just simply saying that I do believe that the function should triumph over the form in this case, and would like to actually respond also further to some of the questions regarding the consecutive foster care issue that was discussed previously, if I may have the opportunity with some of my remaining time. And I would just note that the court's concern is well taken on the fact that the foster care placement of both the appellant and her minor child were together, but I don't think we have facts here that show that the appellant had any interest in taking care of this toddler. We've got paragraph 45 in the order, which on record page 209 and going over to 210 that catalogs again that the appellant's repeated failures here to have anything to do with her minor child making any efforts. I understand that the appellant is a teenager. However, at the end of the day, it is prejudicial to the minor child to continue to have to wait her mother out, so to speak. So in re JGB, the court talks about a willfulness element to that. So it's not just that they are paired together in foster care. It's that if they are, we think that JGB instructs that there has to be some finding by the trial court as to the willfulness of the minor parent not tending to the child. And as discussed in Panoply in paragraph 45 on record page 209 and page 210 and 211, this appellant had repeat instances of disrespect, running away, leaving her child there for the weekend. In one instance, at least one in the record, regarding spending time.
Mr. Peters,
Yes.
your time is up, sir.
Oh, my apologies. Thank you, Your Honor. I'm sorry, I couldn't see the clock.
That's okay.
Thank you for your time.
Ms. Wright.
Thank you, Your Honor. I'll just want to touch on a couple of things briefly. I'll start with Mr. Peterson's arguments since they're fresh in our minds. I would just say that these arguments as to whether or not a move and placement would be disruptive to the child and all that, those related things, those are best interest factors. And the trial court doesn't get to those best interest considerations until after the trial court has correctly determined that there has been clear, cogent, and convincing evidence that one or more of the grounds exist. So, I just want to point that out for consideration when your honors are thinking about that. Also, I would say that, as to the A3 grounds, in the trial court's order, there is a finding of fact about the mother's then present ability to work and earn money, but there's no finding of fact about the mother's ability to work and earn money during the relevant 6-month period. And her
Excuse me, Ms. Wright, if you look at finding of fact number 47 in the order, it will say the court finds that grounds exist to terminate rights on the grounds that she hopefully failed to pay a reasonable portion of the cost of care for the juvenile, although financially able to do so for a continuous period of 6 months next preceding the filing. What do you expect to make of that line?
Well, I would say that is an ultimate finding that's not supported by the evidentiary findings. That her situation in the relevant 6-month period is very different than her situation at the time of the termination hearing. At the time of the termination hearing, she's in this therapeutic foster home, doing well in school, having regular therapy, and not in that period of decompensation, which was the period, the 6 months preceding the filing of the motion. And as to A2, I would, point out to the court in response to the arguments about separation and leaving and removal, that the language of A2 does not say, the parent has willfully allowed the child to remain in DSS custody, or the parent has willfully left the child in DSS custody. It says the parent has willfully left the child in foster care or placement outside the home. And you can compare that to A3, which is the next subsection, which does have a standard about the juvenile being placed in the custody of the Department of Social Services. So I would say, I think the legislature has chosen its wording carefully, and the definition of foster care in the statutes is a placement apart from a parent. And so, again, I just want to reiterate that there is a strong indication here that the legislature is looking for actual separation. And there's also a case that's cited in my memo of additional authority that has a footnote in it. And I know I'm sending the court to a footnote, and I will concede that Henry, JGB, and Taylor and ACF are instructive on this issue, but I don't believe there is a single appellate case in this jurisdiction directly on point. So, we're pulling tertiary things in so the court can make a novel decision on this one. But there's a footnote in Henry KRC where the court is talking about the definition of reunification under the juvenile code, and that is being put back in a home with the parent. So I do think there's a distinction under the juvenile code about actual physical separation in different homes and then being put together in the same home. And then as to the recommendations for higher level of care, there were recommendations that were made by placement providers, but I would also point the court's attention to a record page 163, which actually has the therapist recommendation, which is detailed and dated. It's from the beginning of September, and it has details in it. Thank you. I would ask this court to reverse.
Thank you, Ms. Wright, Mr. Entwistle, and Mr. Christensen. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court. Thank you, Ms. Wright. Mr. Peterson, Mr. Entwistle.
Yeah, thank you. That was a much